Welcome back from the break. You're watching Mirror Now. I'm Riyanka Chaudhary. The Supreme Court lashed out at lower courts and high courts for their reluctance in granting bails, despite the top court repeatedly pushing for the need to be liberal when custody is not needed. The apex court recently heard a bail plea of an accused who was in jail for 14 months even after the charge sheet, only because framing of charges process was delayed. The court remarked that 40% of such cases should be dealt with at the lower court or high court levels. The court had recently said that denying bail where custody is not needed amounts to intellectual dishonesty. Harish is joining us to help us with more on this. Harish, the Supreme Court has lashed out at the lower courts and the high courts for their reluctance in granting bails, despite the top court constantly pushing for the need to be liberal when custody is not needed.
Yes, that's right. Significant remarks coming in from the Supreme Court, which has once again reiterated that the jail should be an exception and bail should be the norm. Once again, the Supreme Court has upheld the principle of right to life, freedom and personal liberty, and once again has expressed its anguish at the manner in which the various lower subordinate courts and high courts are flouting the guidelines laid down by the Supreme Court as far as grant of bail is concerned. Supreme Court, remember, had earlier said that in cases wherever custody is not required, custodial interrogation is not required, and especially in offences where the maximum punishment is less than 7 years, the courts should be liberal as far as grant of bail is concerned, and should not grant custody to investigating agencies of the accused if also the accused is cooperating with the investigation and questioning. So this is in fact I should tell the viewers that this is maybe around 5th or 6th time the Supreme Court is reiterating this principle in the last 3-4 months. And once again, it is Justice Sanjay Kishan Kaul who has expressed concern over this issue. The Supreme Court said that at least for the pendency in Supreme Court can be cut down by at least 40% if the high courts and lower courts follow the Supreme Court guidelines as far as bail is concerned. This is why so many bail applications are reaching Supreme Court, because the lower court and high court is not following the guidelines laid down by the Supreme Court as far as the grant of bail is concerned. So, saying this, the Supreme Court bench has asked the ED to consider bail of an accused, saying that his co-accused all have been granted bail, and the accused in this case, this pertinent case, has been languishing in jail for 14 months, despite filing of charge sheet in his case, only because charges have not been framed. Supreme Court took very serious view of this fact and said that time and again we are forced to state this, but it's falling on deaf ears. We are concerned and angry that lower courts and high courts are not following the Supreme Court guidelines. Remember, the same bench, Justice Sanjay Kishan Kaul bench, had 2 months ago directed Allahabad High Court to send a district judge back to the Judicial Academy, because he had been repeatedly sending accused in very ordinary petty cases to remand in violation of the Supreme Court orders. So Supreme Court has once again reiterated that bail is the norm and jail an exception. Lower courts and high courts should uphold the principle of right to life, right to freedom and personal liberty, and should be liberal as far as grant of bail is concerned, especially in offences where the maximum punishment is less than 7 years. Back to you.
All right, Harish, thank you for giving us an understanding of the observations made by the Supreme Court now on this particular issue. Let's leave it at that and shift